Let the record reflect.
There he is. You recognize that hair by now. Governor Rod Blagojevich mounting what we believe will be a defense in front of the Illinois Senate. Let's take a listen.
He has 90 minutes to which to present his argument. Governor, if I may, please, just to give you some lay of the land. This table over here is yours with the two chairs, and you're at the same podium that was used by the House prosecutor in making his argument. If you need to move a step or two away, that would be permissible as well.
Right.
All right.
Thank you, Justice. Understand that. Thank you. Okay, thank you very much. Mr. Chief Justice, thank you. Ladies and gentlemen of the Senate, thank you very much. I'm grateful for the opportunity to be here today and present my closing argument, my chance to be able to talk to you, talk to the people of Illinois, and talk to anybody else who is listening. I had the last couple of days, I've had a chance to be able to go out and talk to as many people as I possibly could about my desire to be able to appear here before the Senate trial, and have a chance to be able to tell the whole story, have every single witness I could possibly bring be able to tell the truth, the whole truth, and nothing but the truth, present as much evidence as available to be able to have the whole story told, and have a chance to be able to show you here in the Senate, show the people of Illinois, and show anybody else who's listening that I have done absolutely nothing wrong, that I followed every law, that I never ever intended to violate any law, and that when the whole truth is heard and the whole story is told, that's ultimately what will be shown. I was hopeful that I'd have a chance to be able to do that in a Senate hearing, in this trial, a chance to be able to bring witnesses in, a whole list of witnesses, every single witness in the criminal complaint. It would have been nice to have them here so they can tell the truth and tell you under oath what they know. I wanted to be able to bring in witnesses from Rahm Emanuel, the President's Chief of Staff, to Senator Dick Durbin, to Senator Harry Reid and Bob Menendez, to every single person connected with any conversation I may have had in relation to picking a United States Senator. Unfortunately, these rules have prevented me from being able to do that. And in spite of efforts to try to get you to give me that chance to do it, it didn't work. So I went to the people, talked to as many people as I possibly could. And I was over and over repeating to them, just give me a chance to be able to let the truth come out. So sooner rather than later, I can show you I've done nothing wrong. So sooner rather than later, I can clear my name and we can put this behind us and get on with working to do things for people. Get on with the business of the people. Now, when I did that and met a lot of different people and made that case to them, they were mostly sympathetic. They understood my position. They said, of course you're entitled to a fair trial. Every American citizen is. Of course you're entitled to bring witnesses in so you can disprove things that are being said about you and show that they're not true. Of course you're entitled to confront your accusers. This is the United States of America. It's guaranteed by the Constitution. It's a fundamental civil liberty that every American enjoys. And imagine what it would be like to live in a country like this if you weren't allowed to be able to defend yourself. And of course, an impeachment trial is not a court of law. It's different. But whether it's a court of law or an administrative hearing, whether it's schoolyard justice, when one kid hits another, but the kid that hit him wasn't the one who did it, and he's got other boys he'd like to have tell the teacher he didn't do it, whether it's that or whether it's an impeachment process where you are seeking to remove a governor who was twice elected by the people, I think fundamental fairness, fundamental justice, natural law, and constitutional rights suggest I should be able to bring witnesses in to say I didn't do the things they said I did. Now, when I made that case to people, they listened to me and were supportive. But they also said to me, if you feel so strongly about it, Governor, then why don't you go to the Senate and tell them yourself? Why don't you go there and tell them instead of you just telling us? And so that's why I'm here. I'm here to talk to you and appeal to you, to your sense of fairness, your sense of responsibility, your commitment to the Constitution, your commitment to basic fairness. And I'm asking you, as I speak to you today, to imagine yourself walking in my shoes. Think about you if someone said the things that they've said about me and you know you didn't do it, but there's been a rush to judgment and an evisceration of the presumption of innocence. Imagine how you would approach this and what you would do. Think about if you knew you were right and you were innocent and you didn't do anything wrong, whether you should be rushed out of office, disgrace your family, disgrace your children, and imply that you might have actually done the things they said you did. Think about your responsibilities when the people choose you. And you know you've kept your faith with them, but everybody else is saying you didn't. But if you quit and give up and leave without having a chance to prove your innocence, how you've abandoned them and you've quit on them and you've violated your commitment to them. I'm here to give every possible explanation to every one of these allegations, and I'm grateful that you've at least given me that. But I would hope that maybe when you consider what I have to say, who knows, maybe you'll reconsider and give me a chance to call those witnesses I'd like to call. And who knows, maybe you'll reconsider and give me a chance to see if there's some possible way where every one of those conversations that were taped can be right here before you, so you can hear all of them, warts and all, the truth, unadulterated truth. Maybe not flattering in some cases, but it's the truth, and there was never a conversation where I intended to break any law. So I'm here to do what I can to explain to you my side of the story. Now, the articles of impeachment, as they're configured, are broken up basically in two portions. One is a portion that alleges that I abused the executive discretion that the governor has given. And then the other is the allegations in the criminal complaint. Articles 1 through 8 deal with the allegations in the criminal complaint. But here at this trial, only Article 3 was there any evidence presented to suggest that something may have been done. In all the other articles, no evidence was presented to prove up criminal allegations. And let's look at the one article where they actually brought evidence. The evidence is the 4 tapes. You heard those 4 tapes. I don't have to tell you what they say. You guys are in politics. You know what we have to do to go out and run elections. There was no criminal activity on those 4 tapes. You can express things in a free country, but those 4 tapes speak for themselves. Take those 4 tapes as they are, and you will, I believe, in fairness, recognize and acknowledge those are conversations relating to the things all of us in politics do in order to run campaigns and try to win elections. Now, I understand that the federal prosecutor and the U.S. attorney has made it clear, and I respect and understand his position, that he doesn't want witnesses called and that he doesn't want evidence called. And that's why on all the other 7 articles, with the exception of those 4 tapes that you heard, there hasn't been any evidence to show or prove any criminal conduct. I understand that. That's why I am appealing to you that unless they allow us to bring that evidence in, then that case ought to be heard in the appropriate place, in a court of law, and respect the U.S. attorney and his needs to be able to bring those witnesses. But how can you throw a governor out of office on a criminal complaint and you haven't been able to show or prove any criminal activity? How can you throw a governor elected twice by the people out of office when the rules don't even require that you prove up elements of criminal allegations? And more than that, how can you throw a governor out of office who is clamoring and begging and pleading with you to give him a chance to bring witnesses in to prove his innocence, to do more than just ask for a presumption of innocence? Don't even give me that. Let me make my case. Let me bring my witnesses in. Let me show you that I'm innocent and I didn't do anything wrong. So Articles 1 to 8 do not show or prove any criminal case. And if that's the case, how can you throw me out of office without approving something like that and set a dangerous precedent that could have an impact on people and governors in Illinois and governors in other states? Now, the 4 tapes that you heard speak for themselves. You also had a chance to listen to the FBI agent who was here. But what did he do? He just read allegations. He didn't allow you to challenge the allegations. He didn't allow you to cross-examine any of the people involved in those allegations. He simply read a criminal complaint. That's not proving criminal allegations. And again, I would respectfully suggest to you, how can you throw somebody out of office, whether it's me or maybe one day it happens to you, without even expecting someone to try to prove something that they're saying that you did? So I'm appealing to you and to your sense of fairness. And because Articles 1 through 8 don't allow for having proven any criminal activity, I can't imagine how you can possibly throw me out of office for something that wasn't shown that I did. As for the other